Welcome to the Grow Your Law Firm podcast, brought to you by Pilma. This podcast helps lead lawyers to more growth, profit, and freedom. Here is your legal marketing expert and host, Ken Hardison.
Well, hello, everyone. This is Ken Hardison, and welcome to another episode of Grow Your Law Firm. And today we have the honor and privilege of having Ilona Anderson, a trademark and employment attorney with Carpe Diem Law Firm out of Southern Florida. Welcome to the show, Ilona.
Thank you so much, Ken. It's a pleasure to be on your show. I've kind of followed your path, or at least, have been familiar with you for many, many years. I would say circa 2010, 2009, when I was working at a PI law firm, and you were already very prominent. So it was really great to reconnect with you at an event in Miami Beach a couple of months ago, and I'm honored to be invited to your podcast.
Absolutely, absolutely. Well, I mean, as they say, I'm old as dirt, so I've been around a long time.
Well, dirt's really good for you. It's got a lot of nutrients. It's got a lot of good stuff.
And I was reading your bio, and you're an entrepreneur yourself. I mean, you've started and sold several businesses over the years, if I remember correctly.
Yeah, I mean, I've started multiple law firms. So my first venture was I was working at a PI law firm for about 3 years, and then I got pregnant with my first child. This was years ago, 12 years ago. This was pre-COVID, pre-flexible work arrangements. We were working obviously on site. Saturdays were mandatory. And it was really important for me to be able to maintain my career, but also bond with my baby and breastfeed and things like that. So I wanted to talk to my boss to see if maybe we could work something out. Maybe for a period of time, there could be some kind of flexible arrangement or work from home a couple days a week, and he kind of said, look, if we let you do it, we're going to have to let everybody else do it. And this is just not a precedent we want to set, and I understand. And so then I had a decision to make. And within days, I made the decision to go out on my own. And at that time, I was 5 months pregnant. The thought was that it's easier to start up something of my own while the baby's still in the belly. It's going to be much harder when the baby comes out. So I resigned when I was 5 months pregnant, and I started my solo practice. And then shortly thereafter, I met the person who then subsequently became my law partner for the next 10 years. And together we founded and managed and ran a boutique plaintiff side employee rights law firm. And so over the course of those 10 years, we grew that law firm to 7 figures, to 15 team members. It operated like a well-oiled machine, done a lot of personal development, gotten a lot of coaching. And then I made a decision for various reasons. It was time for me to exit that partnership. So upon exiting that partnership, another opportunity presented itself very shortly thereafter that was always intended to be temporary in nature, but it's something that allowed me to replace my income until I figured out my next move. That opportunity was running an ERTC, employee retention tax credit processing law firm. Technically, it was a law firm, but what we were doing, we were a compliance check for a large ERTC filer with the IRS, who wanted to make sure that things weren't getting rubber stamped, that things unlike so many other processors, what they were doing. So we had lawyers. I was managing a team of 7 to 10 lawyers for about a year. And we also had CPAs going through the documents and basically ensuring that the business owners who were applying for employee retention tax credits were fully qualified, either financially or because of the under the impact test. Conducting legal research, sort of kind of like doing a little pre-audit, documenting everything, preparing 941Xs, and then sending them off to the IRS. Like I mentioned, it was always intended to be temporary in nature because the program was going to expire sooner or later. The business wrapped up a little bit sooner than we expected because our client, who was generating, I would say 99.9% of business for us, decided to get out of the ERTC business once the IRS put a moratorium on processing those claims. So then I had to make a decision a bit sooner than expected on what I wanted to do next. And that's how Carpe Diem Law Firm was born.
Great. That's a great story. So a couple things I want to go over today. And we were talking about before we started the show, but I think lawyers, and we've talked about this before on the podcast, you do trademark law too. I think it's very important that a lawyer trademark his name for business purposes and his slogan or his anything to do with his law, any business. I know I probably got 8 or 9 trademarks for the different stuff I do. What would your advice be? And it's not that expensive, is it? I mean, you can get a trademark for like under $2,000, right? Maybe.
Yeah, it's about $2,000, $2,500. It's a
Yeah,
worthwhile investment, and it's so frequently overlooked, because, and not just for lawyers, right? For any founder starting a business, including a law firm, sometimes it's not something that founders think about. What they think is, oh, when I'm bigger, I'll trademark. When I have the money, I will trademark. And so the reason that thinking is a bit backwards is, well, number one, if you don't own your trademark, then you could potentially be building somebody else's brand. Somebody else can go and register it, and then you have to face the possibility of rebranding or face a cease and desist letter and a possible infringement lawsuit. And the average cost of rebranding is about $30,000. The average cost of defending yourself against an infringement lawsuit is in the 6 figures. So the $2,000, $2,500 to spend on a trademark is money well spent to make sure the business is yours. Another fallacy in thinking that I'll wait until I'm bigger is that part of registering a trademark, especially, using a lawyer, and I would highly recommend using an attorney, it's more than just going to uspto.gov and filling out forms. Part of it is making sure that the name you're choosing for your business is actually something that could be registered, and it's something that is available to be owned by you. And so any attorney who would be engaged by a client to register a trademark would first conduct a comprehensive clearance search to make sure that name is available. And now the availability of the name goes a lot deeper than just going to Google or uspto.gov and looking for exact matches. Because from the perspective of the USPTO looks at the likelihood of public confusion, right? And names don't have to be identical to pose a likelihood of confusion. So when an attorney does a comprehensive search, we'll look at singular and plural, we'll look at different spelling variations, because people think, oh, I can come up with a cutesy alternative spelling and, that avoid any conflict. It doesn't work that way. We'll look at phonetic variations or similar phonetically sounding names, even if they're spelled differently. We'll look at similar connotations, even if the words are different, if the impression is the same. We'll look at different word combinations, as well as foreign translations of the words. And so based on that, we provide a search report to our client, along with an opinion letter that assesses the risk level, the risk that the registration would be denied. And then based on that information, the client can make a decision, okay, I move forward with this name, or I rebrand. And another reason why it's so important to do early on is because the USPTO currently takes about 8 to 10 months to even start looking at your trademark application. And of course, when you're a business owner, you don't sit around doing nothing for 8 to 10 months, right? We're putting money into our business, we're marketing, we're growing our brand, we're getting our name out there. So you could be spending, 10 months or a year getting your name out there, only to then receive a rejection from the USPTO, letting you know that your name is not available, or it's too descriptive, or it infringes upon somebody else's name. And that's a lot of it. Most of it could be prevented with just some proactive, preventative lawyering by early on aligning yourself with an attorney who can do a comprehensive search for you.
And listen, the other thing I know is sometimes I've got them and I didn't use them, but I got them because I want to go ahead and get it in case I did want to use that name or that slogan.
Mm-hmm.
And sometimes you can. I actually made money off of one. I actually did one that I was going to start this business, and I decided not to. And a guy called me and says, "You got this, and I want it." And I sold it to him for $130,000. You never know. Yeah.
You never know.
Well, I asked 150. I asked 150, but he got me down to 130. But the deal was, I mean, it cost me a couple grand to get that. And I might have used it, but I decided I didn't want to go, I'm getting old. I didn't want to start another business. And so I decided to, but it was evidently a good idea because somebody else is going to do the same thing and they wanted that name.
Mm-hmm.
So you never know. I mean, it's the only one I've ever sold, but you never know. You just never
You
know.
never know. That's an amazing story. That's an amazing story. And you also bring up a different point because a lot of people think that they can't apply for a trademark until and unless they're using that name in commerce. And that's not true. There's two different trademark application types. There's what's called a 1A, which is when you're already using that brand in commerce, and there's a 1B called intend to use. So when you're not using it in commerce yet, but you're intending to use it within a reasonable time, meaning a couple of years,
Yeah.
and you can still get it trademarked. You will not get the registration. You will not get the Circle R until you're using it in commerce, but you get the priority filing date, right? So if somebody else files a week later, a month later, a year later, you still have priority because you filed your application, even if you're not using your brand in commerce. And then the USPTO allows you to get up to 5 6 months extensions. So if you look at the initial review period of about a year, plus up to 5 extensions, you have about 3 years to decide if you want to launch that business and actually launch it.
Yeah. So, I mean, you never know. Like I said, I want to talk about employment law because, I mean, this even comes up with any kind of business, but I think law firm owners get confused and are putting themselves at risk by not paying people overtime. It's also this independent contractor. And we talked about this before we started. Some people think you give them, you do a agreement, say you're an independent contractor, and give up, file it with IRS and that they're independent contractors. So let's talk about each one. You can pick everyone you want first, and let's go through it and talk about
Yeah,
where people
those two, I'd be happy to talk about both of them, and both of them are really big landmines when it comes to employment law. It's actually one of the reasons I started in my prior law firm. I was focused on primarily plaintiff side employment law. Now about half of my clients are entrepreneurs because I recognized how many landmines there they can trip somebody up and cause a big problem, and you don't have you could be well-meaning. I believe that most business owners are well-meaning and they want to comply with employment laws. It's just sometimes they're ignorant of their application. Not everybody. I mean, being on a plaintiff side, I've seen it all, and we've had a lot of intentional repeat violators, but for the most part, I think business owners want to comply with the laws, or they underestimate the risks in connection with incorrect application. So let's talk about overtime first. You're absolutely right. Non-payment of overtime is a huge issue. So sometimes, and there's two most common ways employers avoid paying overtime. Number one is having somebody work more than 40 hours a week and then not having them clock out at 40 hours on the dot and not paying them for any extra hours worked on top of 40. So the law, Fair Labor Standards Act, requires the payment at the rate of 1.5 times the regular hourly rate for all hours worked in excess of 40 per week. And I've seen some of the interesting defenses in my career, and some of them was, well, if you see how many hours the person worked over the course of the year and divided by the number of weeks, you can see the average weekly number of hours was well below 40. Well, that's not how it works, right? Just the other day, I had an inquiry from a potential client that basically said, my employer is having me work 50 hours one week and then 30 hours the next week and not pay me overtime because it averages to 40 hours per week. So from the perspective of the FLSA, a work week is defined as a period of whatever, Monday through Sunday, or starting from any day, 7-day period. And during that 7-day period, if the person is getting paid, is working more than 40 hours a week, they have to get paid time and a half for every hour worked. And then the second way employers often avoid paying somebody overtime is by classifying somebody as exempt without really ensuring that it is an exempt position duties wise, right? We see somebody having an exempt label slapped on them. We have a store clerk is called a manager, but in reality, 80% of what we do is stocking shelves. Like, that's not permissible. There are some exemptions under the law. There is an administrative position, there is managerial position, there's an executive exemption, there is highly compensated employee, outside salesperson, IT professionals. So there's a variety of exemptions under the FLSA. In a law firm or office setting, the most common are the managerial and the administrative. and this is the issue we often see with paralegals, for example, right? They would call somebody a paralegal and have them work 60 hours a week and not pay them overtime because they're exempt. But in reality, to be exempt, not only do you have to be paid a certain weekly salary on a salary basis. I believe the current number is 684 per week. It went up briefly, or there was a proposal, and that proposal did not go into effect. But also their functions have to be that of a manager, of an executive. So they have to oversee the work of 2 or more employees. They have to have decision-making authority regarding hiring and firing of people, or at least exercise substantial influence over those decisions. And so if those factors are not present, just because you call somebody a manager, just because you call somebody an admin, it doesn't mean they're automatically exempt from overtime. You still you have to very closely follow the FLSA requirements. And then I'm happy to talk about the independent contractor confusion because we see this all the time.
Yeah. Let's talk about that.
So as entrepreneurs, as founders, we all want to hire independent contractors versus employees because then we don't have to deal with taxes. We don't have to deal with payroll. Then we don't have to deal with benefits. We don't have to deal with tracking hours. It's very convenient and so much easier to have independent contractors on staff rather than employees. And the big misconception is that as long as your worker agrees to be an independent contractor and signs an independent contractor agreement, and you pay them, you provided 1099 at them at the end of the year versus a W-2, then you're in the clear. They're an independent contractor. But in reality, that's not how it works. The Department of Labor and the IRS both have what's called an economic realities tests, and those tests are almost identical, where they have 6 different factors to evaluate the true economic realities of the relationship. And a lot of it comes down to the degree of control you have over your worker and how economically dependent they are on you. Because technically, an independent contractor is in business for themselves, right? So they usually would set their own schedule. They would decide how they do the work and when they do the work and where they do their work. They usually get their own tools. They usually get their own insurance or equipment, could be a laptop in an office setting, right? That's a tool. They would generally be providing services, or at least have the ability to provide services to other clients versus just having an exclusive permanent relationship. And usually with an independent contractor relationship, most of the time it's not permanent and the function is not integral to the business or something more tangential. Versus the employment relationship, the more control, the more you're setting their time and hours, controlling their schedule and telling them how to do their work, making them comply with your system policies and procedures, giving them performance evaluations, making them wear a uniform, providing them computers and equipment, precluding them from working for others. All of that screams employee. So none of the factors are dispositive in and of themselves, but the courts look at it in the totality of the circumstances. So I actually put together a guide how to determine if somebody is an employee or an independent contractor under the latest Department of Labor guidance. So if any of the listeners would like that guide, I can send it to you, Ken, or they can reach out to me. I'd be happy to
send it, and we'll put a link on the notes in the along with how to get it with you.
Okay, fantastic.
Yeah. So yeah, I mean, and here's the deal. I've only been sued one time, or not. I didn't get sued, but I got somebody hired a lawyer, which I think I'm really lucky after almost 40 years in business, different businesses. And it's not, when I hired a lawyer, local lawyer, I said, we're not talking about hardly anything. He said, that's not the problem. The problem is attorney fees. He said, that's where you're going to get, that's where you're going to get hurt. It could be a $10,000 claim, but you might pay $50,000 in attorney fees if you don't, and even if you sell it up front, you still got to pay attorney fees most of the time, though. I mean, that way it works.
Yeah, and this is a really good point that you bring up, is that those lawsuits seemingly they are low risk, right? Because we're talking about some overtime with some minimum wage claims.
Yeah.
But in reality, they can be very risky for the business owner because of how damages are calculated. So number one, almost automatically under the FLSA, the employee gets liquidated damages that double the amount of their actual proven unpaid wages. So let's say your employee sues you for $10,000 and proves $10,000 in unpaid wages. Almost automatically, they get $20,000. I mean, technically, it's when a violation is proven to be willful, but I can tell you, I don't think I've ever not been able to prove a willful violation. I think that goes for the majority of my colleagues. So, because willful is knew or should have known, right? It's not that I'm trying to screw my employee. It's, you should have known. You're a sophisticated business owner. And then the FLSA also has a fee shifting provision, which makes the losing employer responsible for the prevailing employee's attorney's fees. So then as a business owner, you're paying your own attorney to defend yourself, to defend you or your business and you have to, because a business cannot be pro se in court. A business has to have an attorney. Then you're paying the unpaid wages that your employee has been able to prove, then you're paying a double amount in liquidated damages, and then you're also paying your prevailing employees attorney's fees, which are usually they're subject to approval by the court and subject to a fairness evaluation, but general rates are $450 to nowadays even $500 an hour, for the work that's been done. So it could be very expensive, which is why most of those cases settle early on, and which is why also some of the unscrupulous plaintiffs and attorneys pursue those claims even when there isn't a lot of evidence, unfortunately. This is where also another important obligation for the employer comes in is the record keeping requirement under the FLSA, because the employer is required to keep track of the hours worked by their workers, by their employees, the hourly rate, their schedule, when they clock in, when they clock out, if they're hourly employees, how much overtime they're working. So in a court of law, if an employee makes a claim and the employer does not have records to disprove it, the employee is almost automatically entitled to a presumption of validity, right? Because the employer has not complied with their obligation. Yeah, it's a rebuttable presumption, but if you have not complied with your record keeping requirements, then you can't rebut it.
Yeah. Mm-hmm. We hadn't talked about this. If you don't want to do it, you don't have to. But I got this hypothetical, and I've seen it happen a couple of times in my masterminds, and I just don't know what to tell them. So you got somebody that works with you 40 hours a week, and they pay them, and if they work, on the job like a paralegal, and they do work overtime doing the paralegal work, they'll pay them time and a half, no problem. But at night and on weekends, they have their calls go to them, and they only pay them per call as an independent contractor. That's is that shaky ground, or is that, you know what I'm saying?
It's shaky ground in a sense that if the duties they're performing at night are really not that different from the duties they're performing during the day as a W-2 employees, the only difference is they do it after hours, from their own home, then again, you have to look at the application of the economic realities test. You may be better off having them track the time spent on those calls and paying them over time that way. Or if you have a contractual arrangement to where you're paying them, some kind of a flat fee for those calls, just make sure that exceeds the minimum wage rate and the overtime rate. This way, there's no reason for them to claim misclassification, because why do employees raise misclassification issues, right? Like an employee may be fine being a 1099 worker and they sign an independent contractor agreement, and at some point they kind of turn on employers and say, okay, I've been misclassified and I really should have been a W-2 employee. That usually happens when they divide up the number of hours they're working by their hourly rate and they realize that they're getting paid well below the minimum wage or below what their overtime would have been had they been employees. So it would be more advantageous.
And I think what I'm seeing is they're paying them way more than what time and a half would be. But the problem is just paying them for that call. But they go home at 5:30 or 6, and they got to be on call till 10 o'clock. So although they might not be taking call, they still got to be on call. So is that if you got to pay them for that time that they're on call, or just when they do the call? You know what I'm saying? That's the thing that gets me. That
Yeah.
worries me. But I don't know.
Yeah.
I'm not an employment lawyer, so I don't know the answer.
Yeah. And so on-call time, yeah, generally on-call time is considered to be work time if the time does not fully belong to you, right? If you're not free to do whatever you can and can be pulled away at any minute to do something work related and you have to be by your phone, then technically you should be getting compensated for that.
See, that's what I was afraid of.
You know, another option would be to hire another worker to cover the after working hours work and just hire them as an employee or depending on the circumstances, maybe as an independent contractor, but instead of like going into this gray area, because from the perspective of the employer, you know, I get the point. It's like if they only get one phone call during those 6 hours, then you really don't want to pay them for those 6 hours, right? That they're technically on call. But from the perspective of employee, it's like, well, we can't fully own our time, be relaxed, go to the movies, you know, go out to a club, because at any point we may need to be on a call and be professional and not be drinking alcohol and not have the kids screaming. So I think that probably a more practical solution would be to just have another person covering that time and have a separate, maybe independent contractor arrangement where you're just paying them, you know, per project, per call or something like that.
Yeah, and my recommendation was because he had like 2 intake people. I said stagger them, get one to come in at 8 and work, to a 4 or something, and get another one to come in like 2 and work to like 10.
Mhm.
That way you still paying 8 hours, but you're staggering their hours.
Yeah, you
But
can also hire somebody offshore via an agency, and then you don't really have to worry about that because they're the agency's employees and they take care of everything, and you just pay in a flat
yeah,
rate to have them
and,
available.
and really, it probably doesn't matter in the next 12 months. AI is going to be doing voice agents, and we're not going to have people doing it. It's going to be these avatars doing it, I think.
That fascinates me so much. You know, I see so much content all over social media about AI intakes, and I've not seen it work really well yet. You know, what I've seen yet is still very glitchy, and maybe it works for some when it was very straightforward qualification for employment law, especially for plaintiff side employment law. The qualification is not, it's very, very extremely nuanced. You know, it's not just we're going to ask you 5 questions and yes, you're a qualified lead or not a qualified lead. It's more like,
Yeah.
you know, 25 questions at the very least to determine if they're a qualified lead. So I struggle to see how it would apply at this stage to plaintiff side employment law. I can definitely see how it would apply to, I don't know, bankruptcy and immigration and estate planning and even employment law compliance, right? If somebody tells me, you know, they need a contract or they want me to do a wage and hour audit, certainly AI can handle that initial pre-qualification, or for trademark. So if somebody says they have a brand and they need to conduct a comprehensive search and apply for federal registration, certainly.
Is there anything lawyers or any employer needs to worry about if they use offshore people? I mean, as far as employment law or tax law or anything. I mean, anything. I know you're not a tax expert, but
Yeah. So it depends if you're hiring them directly or if you're hiring through an agency, right? The benefit of hiring them through an agency, a staffing agency, is that the staffing agency takes care of everything for you and they're technically provided to you, you know, as a resource, but they're employed by the staffing agency. If you're hiring somebody directly as an offshore contractor, you could do it. You still have to make sure that they comply with the economic realities test and that they're working for you as an independent contractor and not as an employee. In some cases, you may need to be aware of some, you know, intricacies in employment laws in their home jurisdiction. As far as the IRS requirements, there is a form. I don't remember exactly the name of the form, but there is a form that needs to be filled out with the IRS that basically confirms that they're doing work from abroad and confirms their status as an offshore independent contractor. So, you're not responsible for collecting taxes. Make sure it's truly independent contractor relationship. Be aware of any laws in their home jurisdiction. And then with the IRS, file that it's literally like a 2-page document that just confirms that they're an independent contractor working offshore. And of course, if they come to the United States, that could be questionable if they can even work for you from U.S. soil because, they don't have a work permit or authorization if they come, for example, on a tourist visa. So I probably should talk to an immigration attorney on that, but chances are it's fine as long as they're working for you from abroad, but may not be okay if they actually come to the U.S.
I think immigration attorneys are very busy now. Trump's got them very busy.
Oh, yeah.
Shipping everybody off. So I thank you so much. And if somebody wants to talk to you or get up with you, how's the best way to do that?
Sure. So you can go to carpediemlawfirm.com, carpediemlawfirm.com, and all my contact information is there. You can also send me an email at ianderson@carpediemlawfirm.com, and all my social media links are also on my website.
Okay. Thank you so much. And this was interesting. You taught me some new stuff today. I always like to learn. So good deal.
Thank you so much for inviting me. And you certainly are very familiar with a lot of the topics, so it was easy to talk to you. And I love the story about selling your trademark. I've never actually known anybody personally who has done that, so it was very cool to hear.
Yeah. Thank you. All right. Until next time, this is Ken Hardison, dedicated to your success.
You have been listening to the Grow Your Law Firm podcast, the podcast that leads lawyers to more growth, profit, and freedom. Go to growyourlawfirm.com to find more ways to market and manage your law firm. Please leave us a rating and review wherever you listen to your podcasts.